Before discussing on the topic as such, let me ignite this audience with the recent judgment of the Supreme Court for a clearer concept of what I would like to say in furtherance of the topic. In re directions in the matter of demolition of structures, writ petition civil number 295/2022. It just came 3-4 days ago. It's not yet reported in the reports. The judgment written by Justice B.R. Gawai along with Justice Vishwanathan said, and I quote, "If a citizen's house is demolished merely because he is an accused, or even for that matter a convict, that too without following the due process as prescribed by law, in our considered view, it will be totally unconstitutional for more than one reason. Firstly, the executive cannot declare a person guilty, as this process is the fundamental aspect of judicial review. Only on the basis of accusations, if the executive demolishes the properties or property of such an accused person without following the due process of law, it would strike at the basic principles of rule of law and is not permissible under the Constitution. The executive cannot become a judge and decide that a person accused is guilty and therefore punish him even before the court could convict him by demolishing his residential or commercial properties. Such an act of the executive would be transgressing its limits." The Supreme Court went on to say, "The chilling sight of a bulldozer demolishing a building when authorities have failed to follow the basic principles of natural justice and have acted without adhering to the principles of due process reminds one of a lawless state of affairs where might was right. In our Constitution, which rests on the foundation of the rule of law, such high-handed and arbitrary actions have no place. Such excesses at the hands of the executive will have to be dealt with the heavy hand of the law. Our constitutional ethos and values would not permit any such abuse of power, and such misadventures cannot be tolerated by the court of law," unquote. This is one stark example of executive excesses in recent years. Further, and in the era of tribalization or tribunalization, however you want to pronounce it, the constant refrain is that the executive trenches into areas of adjudication and therefore accused of usurping judicial functions by appointing persons with executive bias. The reason is, they say that the high courts have so much of docket load, so much of pendency. Therefore, let us create tribunals to unload the pressure on the High Court. Initially, it started with the Service Tribunal, Central Administrative Tribunal, State Administrative Tribunals, and that experiment has failed in certain states, and the matters, I am told, have gone back to the High Court. But then it went on from one tribunal to another tribunal to another tribunal. No doubt, in some cases, the tribunals may be a good opportunity for retired judges to have a rehabilitation. But at the same time, who are the members, technical or otherwise, who are assisting such judges is the question. In Roger Matthew, the Constitution Bench of the Supreme Court issued a writ of mandamus to the Ministry of Law and Justice, central government, to carry out a judicial impact assessment of all the tribunals. The central government responded with the notification of tribunal, appellate tribunal, and other authorities' qualification, experience, and other conditions of service of members' rules 2020. This was again challenged by the Madras Bar Association on the ground that the rules were violative of the principles of separation of powers and independence of judiciary. The Supreme Court has directed that the Union shall constitute a National Tribunals Commission, which shall act as an independent body to supervise appointments and functioning of tribunals, to consider disciplinary proceedings, and to take care of administrative and infrastructural needs of tribunals. This is in order to maintain independence in judicial adjudication. The call of the modern technocratic, transparent, and efficient governance structures beckons a constitutional regime of checks and balances that travels beyond traditional state actors. Rather, the structure of 21st century open governance frameworks makes it prudent to acknowledge that the regime of checks and balances also responds to citizen participation.
द वायर के और वीडियोस देखने के लिए सब्सक्राइब करें और बेल आइकन पर क्लिक करें। स्वतंत्र पत्रकारिता की आर्थिक मदद करने के लिए डिस्क्रिप्शन में दिए गए लिंक पर जाएं और अपनी राशि चुनें।